Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law number 2. This morning, we have two dockets. We have our motion to revoke probation docket and our announcement docket. When I call your name, please come forward before the bench with your attorney. If your attorney is not here, we will wait for your attorney to arrive because your attorney may be in another court handling another matter. If you are not represented by an attorney or if you are representing yourself, when I call your name, please come before the bench by yourself. First case is Kalen Johnson. Mr. Johnson is on Zoom. Mr. Johnson, you
How
can
you doing?
take back off of mute. Mr. Johnson, how are you doing?
I'm doing good.
Okay, Mr. Johnson, you're represented in your case by your attorney, Attorney John Macy. Mr. Macy, how are you doing?
I'm fine, Your Honor.
Okay.
But
Oh, I'm doing fine. Thanks for asking. And the state is represented in this case by Attorney Cornelius Williams. Mr. Williams, how are you doing?
Doing well, sir. Thank you. And how are you and your staff?
We're doing fine. Thanks for asking. And Mr. Macy, what is your announcement in Mr. Johnson's case?
Your Honor, I got this is the first appearance on Mr. Johnson for me. I think we'll be able to resolve this case. But obviously I have to run it by Mr. Johnson. He's on Zoom.
Okay,
So if we could reset it for,
give us a standard reset.
yeah, standard reset.
Okay, this case will be reset to April 8th at 9 a.m. in County Court at Law number 2. Mr. Johnson, on that day, you need to be here in person. Your attorney and your bondsman will be given notice of this court date for April 8th, 2026 at 9 a.m. Stay in
Okay.
contact with your attorney and your bondsman. You're free to go and you have a blessed day.
Yes, sir. Thank you. You too.
And you're welcome. And Mr. Macy, this is your only case?
I have one more, Judge, but that is gonna be a plea.
Okay.
And I sent it, so it's working its way to you.
Okay,
What's your name? It's not really yours.
For which one? This is Cleveland?
Yeah. I got 2560.
That's what,
2560.
Mr. Bauer, your full name is Andreas J. Bauer.
Yes, sir.
How are you doing, Mr. Bauer?
I'm doing fine now.
That's good, Mr. Bauer. You're represented in your case by your attorney, Attorney Todd LeBlanc. Mr. LeBlanc, how are you doing?
Good, Judge, thank you.
And Mr. LeBlanc, what is your announcement in Mr. Ibarra's case?
Judge, we need some more time to sit down and talk, and I haven't been able to get with him.
Okay.
So I think this is first thing for us.
Okay.
We can, rather than set on phones, call out, if we did it, let's go back, but he's.
Okay.
See if we can work it out.
Okay, Miss Segura, could you give us a court date for Mr. Andreas Ibarra, page 6? Announcement docket, top of page 6.
April 8th.
Okay, this case will be reset to April 8th at 9 a.m. Mr. Ibarra, you'll get your reset from our court coordinator. Once you get your reset, you're free to go.
Thank
You have a blessed day. Stay in contact with your attorney and your bondsman.
Yes, sir.
All right, you have a blessed day.
You got that?
Jacqueline Deshawn Howard.
Talking about Shaylon Johnson, he was talking about Mark Proctor. They tell me Mark Proctor, that's what they claim the number.
Okay, well, I can't put it into that number.
It's on the sheet. It's on the reset.
Well, I said.
Okay, Mr. Howard, how are you doing? I'm doing fine, thanks for asking. Mr. Howard, you representing your case by your attorney Todd LeBlanc. Mr. LeBlanc, what is your announcement in Mr. Howard's case?
Saying that, if I can have a little more time. See if we can get it worked out.
Okay, now Mr. Howard has 2 cases. Give us a reset, standard reset.
April 8th. What's the,
It's on page 5. Howard. Both cases, these cases will be reset to April 8th, 2026. Mr. Howard? Mr. Howard? I didn't tell you to leave. Okay? Now, Mr. Howard, your cases will be reset to April 8th, 2026 at 9 a.m. On that day, you need to be here in court. You will get your reset from our court coordinator. Once you get your reset, you'll be free to go and you have a blessed day. Okay.
Yeah. You go read
This class is not here.
I don't think you did that one.
Oh, no.
Not in the slightest.
I'm talking about getting over.
Oh, yeah. She's kind of like enjoy.
Mr. Lawrence, you here on LaTravion Coleman?
All right, John.
Hey, Mr. Coleman, you need to remove the comment out of your mouth.
I'm having a little trouble hearing you.
I wasn't talking to you. Okay. Now, Mr. Coleman, how are you doing? I'm doing fine. Thanks for asking. And Mr. Coleman, you're represented in your case by your attorney Jack Lawrence. Mr. Lawrence, how are you doing?
Just fine, Your Honor.
And Mr. Lawrence, what is your announcement in Mr. Coleman's case?
Well, we're going to plead no contest, Your Honor, based on the Second Amendment to the Constitution.
Okay, now, Mr. Lawrence, you need to fill out the tablet if you're gonna enter a plea. Okay, so you need to fill out the tablet.
It's an open plea to the court.
I understand, but
This is an open plea.
I understand, but you still have to fill out the misdemeanor plea admonishment and the trial court certification. The plea is open, that deals with punishment. Okay, you still have to fill out the paperwork. They will not make a punishment recommendation. That's the only thing that's different.
Well, if I could get a tablet,
Okay, well, there's some tablets out there. Just, we're gonna.
What's committed on punishment?
Punishment? Okay, he's saying it's an open plea. Okay, what an open plea means that you're entering a plea either guilty or no contest to the charges. And then you don't have an agreement with the state, the district attorney's office. Apparently you have not accepted their offer. And so the court will set punishment anywhere within the punishment range. And you're charged with a Class A misdemeanor. And so the court can set punishment anywhere from 0 days to 365 days in the county jail, or you could be given a fine that does not exceed $4,000, or you could be given both such fine and confinement. You may be eligible for probation. There are two types of probation. One type of probation is called unadjudicated probation. With that type of probation, you don't have a conviction on your record, and if you successfully complete the probation, the case will be dismissed and you may qualify for a non-disclosure. And a non-disclosure means that your record on this case will be sealed to the general public. Now, the other type of probation is called adjudicated probation. With adjudicated probation, it is a conviction on your record. However, there's something that is called, there's a law that's called judicial clemency, which means the court, meaning the judge, can set that conviction aside, and you can get you will no longer have a conviction on your record. Okay. Now, however, if you get a subsequent conviction, that is another conviction later on, then the case that you receive judicial clemency on can be resurrected, brought back up, revived, and used against you. And if you try to get a license with Child Protective Services, they could deny giving you a license, or if you have a license, they can revoke or suspend your license. So basically, with the open plea, you're saying that I'm not accepting the plea agreement that the state is offering me, and I want the judge to set my punishment. Okay?
Our open plea is based on the Second Amendment.
Well, regardless, I understand what it's based on, but I'm explaining to him what an open plea is. He may not understand. That's your job to explain that to him.
All right, and there's one other thing. He's willing to give up the guns.
Okay, well, we will get to that later on, but you still have to fill out the paperwork if he would like to do an open plea. If he doesn't want to do an open plea, that's his right, and we can set the case for a trial.
Oh, and we
Okay.
can set the case out?
You can set the case for a trial. If he's not
On an
entering a
open
plea,
can't we?
if he's not entering a, I don't know, you're saying that he wants to do an open plea. If he does an open plea, then the court will set punishment.
All right,
Okay, but you still have to fill out the paperwork on the tablet before we can get to the punishment. As you know, we have a bifurcated trial system. We have the guilt and innocent phase, and then we get to the punishment phase. The paperwork on the clipboard, on the tablet, is for the guilt and innocence phase. Okay? So he's entering a plea of either guilty or no contest. And then once we get that out of the way, then we'll go to the punishment phase. And then both sides can make arguments as to what you think the punishment should be. And then the court will make a decision and will set punishment.
well, I suppose that the court will give its reasons for overcoming the Second Amendment right.
Mr. Lawrence, if you would like to have a trial, we can give you a trial and you can explain that to the jury.
So to argue the Second Amendment, I would have to have a trial?
Who are you going to be arguing to? I can't take facts right now.
Huh?
You're going to argue that to the jury, or you're going to file some type of motion, but
We could argue it just to the judge.
yeah, we have no, the court doesn't have an motion just before me. Now, you saying that you're going to enter a plea and then you're going to say, I should not plead because of this, or the court should not accept this plea because of this? That doesn't make sense. So either you're going to enter a plea or you're not going to enter a plea. That's
Well, it's an
that,
open plea
I
based on the
understand that.
Second Amendment.
I understand it's an open plea. When you enter an open plea, you saying I'm entering a plea of guilty or I'm pleading no contest.
No contest based on the Second Amendment.
Okay, well, no contest. But the court, if you want the court to set punishment, the court is going to set punishment. Yes,
But you have to consider the Second Amendment, I believe.
it doesn't, if you need to, okay, I can't enter into no plea bargain agreement with you. Okay? You only could do that with the state. That's a contract that you enter into with the state, not with the court. Only thing I'm here to do is to, if you're gonna enter a plea of no contest, no, or guilty, then fill out the paperwork. That's the first thing you have to do. Once we get the paperwork filled out, then we'll go to the punishment phase. Okay?
And you will decide the Second Amendment issue.
You do not have a motion before this court. Did you file a motion?
US Constitution.
Did you file a motion for the court? That's how you bring things before the court in the form of a motion. You don't just come up here and say,
It's in the Constitution, Your Honor.
right. But you did, my question to you is, did you file a motion?
Well, could you give us time to file a motion?
Well, if you want time to file a motion, you can file a motion.
Well, we don't have that available right now to file a motion.
Well, it's not gonna happen right now. The case will be reset to give you time to file your motion, and then we'll give you a hearing.
Yeah, we would like a case reset for us to file a motion on the Second Amendment.
Okay, that's what I just said.
Sir?
Okay, so get with the, your case is gonna be reset. Give us a reset, now you're gonna get your motion filed, and then we'll give you a hearing.
Good,
Here?
good.
He's gonna file a motion, it's gonna be a pretrial hearing. Put it on pretrial. Okay,
All right, fine, Your Honor.
all right, just get your reset.
Okay.
Oh,
So simple.
it in your client, Joe?
I don't believe you from deal judge, but I do have a motion to withdraw.
Okay, well, I don't know if that. Court is in session in cause number 25 CCCR 0462. The case is styled the state of Texas versus Esteban Rivera Garcia. Esteban Rivera Garcia was scheduled to be in court this morning at 9 a.m. At or about 9 a.m., the bailiff called the name of Esteban Rivera Garcia at the courthouse door. Esteban Rivera Garcia did not answer. He has not appeared in court since the court has been in session. The time now is 9:36 a.m. on today's date of March 4th of 2026. Mr. Bailiff, would you please call the name of Esteban Rivera Garcia at the courthouse door? Esteban Rivera Garcia. Esteban Rivera Garcia. Okay, Esteban Rivera Garcia. Name was just called at the courthouse door. Esteban Rivera Garcia did not answer. He has not appeared in court since the court has been in session. His attorney Charles Rojas, is present in court. And Mr. Rojas, you mentioned to the court that Mr. Garcia at one point was in ICE custody.
That's correct, Judge. As of October first of 2025, he was in ICE custody. We checked again November 19th of 2025, and he was no longer in ICE custody.
So he's no longer in ICE custody, okay? State, do you have a motion?
Motion for a bond forfeiture, Judge.
Okay,
Warrant issue.
okay, that will be granted. Esteban Rivera Garcia's bond will be forfeited. Warrant should be issued for his arrest in cause number 25 CCCR 0462. Right? Next case is cause number 25 CCCR 0368. Case is filed in the state of Texas versus Barry Allen Richards. Barry Allen Richards was scheduled to be in court this morning at 9 AM, at about 9 AM. The bailiff called the name of Barry Richards at the courthouse door. Barry Richards did not answer. A reasonable time has passed to give Mr. Richards an opportunity to appear in court. The time now is 9:38 AM on today's date of March 4th of 2026. Mr. Bailiff, would you please call the name of Barry Richards at the courthouse door?
Barry Richards. Barry ready. No response, Your Honor.
Okay, Barry Richards' name was just called again at the courthouse door. Barry Richards did not answer. Reasonable time has passed to give Mr. Richards the opportunity to appear in court. State, do you have a motion?
State move for bond forfeiture warrant issue, Your Honor.
That motion will be granted. Barry Richards' bond will be forfeited and a warrant should be issued for his arrest in cause number 25 CCCR 0368. Next case is cause number 25 CCCR 1730.
Judge, I believe when that case has been
It's
reset.
reset.
Oh, it was reset?
Yes, he was approved for pretrial diversion.
Oh, okay.
That's correct, Judge.
That pretrial diversion. That's your last case?
Yes, sir.
Okay, Mr. Rojas, you're free to go and you have a blessed
Thank
day.
you, Judge. You too.
You're welcome. Mr. Okay.
Yes, ma'am.
Let me just cover anything.
Ms. Robbins, your full name is Catherine G. Robbins?
Right.
How are you doing, Ms. Robbins?
Good.
I'm doing fine, just thanks for asking. Ms. Robbins, you're representing your case by your attorney, Jansen Bailey. Mr. Bailey, how are you doing?
I'm doing well, Your Honor.
That's good. Now, Mr. Bailey, what is your announcement in Ms. Robbins' case?
We're gonna request this case be put on the plea docket, Your Honor.
Okay, give us a reset date.
Should be available in 10 minutes.
Okay,
Yes, sir.
thank you.
Make it available now. Yeah.
What did you say the blood was?
Okay, this case will be reset. This case will be reset to April 6, 2026 at 9 AM. Ms. Robbins, you'll get your reset from our court coordinator. Once you get your reset, you're free to go. And you have a blessed day. And Mr. Bailey, I think this is your only case. You're free to go as well, and you have a blessed day.
I have a, well, is it gonna be dismissed? I had an MTRP, okay.
You have an MTRP?
That's one once we talked about.
Yes, sir.
It will be dismissed.
All right.
Is that Everett?
Yes, Your Honor.
Okay.
I can, just so the court, there's a second one, Your Honor.
Another case number?
Another dismiss, no.
Oh,
A different, on Mr. Hector Maldonado.
Okay, to be
There would be,
dismissed.
well, no, not Hector, no, I apologize, Judge. Tanika Mose
Okay,
would be a dismissal, not Hector Maldonado.
okay,
I'll get around to those, Judge.
okay, okay.
All right. Mail you, Your Honor?
Yeah, unless you want to copy,
I would actually.
okay,
Or he can wait for it. I don't need to wait.
okay. We'll give him a copy of the dismissal.
Thank you, Judge.
Okay.
Thank you, State.
Of course.
Court is in session in cause number 25 CCCR 0852, case of style of state of Texas versus Josiah Thomas. Ms. Thomas, is that your full name? Ms. Thomas, would you please raise your right hand? The other hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, Ms. Thomas, you may put your hand down. How are you doing, Ms. Thomas?
Good.
I'm doing fine, thanks for asking. Ms. Thomas, you're represented by your attorney, Attorney James Paget. Mr. Paget, do you waive a record in Ms. Thomas's case?
Yes, Your Honor.
Ms. Thomas, I have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Josiah Thomas, on or about December 2nd of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of assault causing bodily injury. Ms. Thomas, do you understand what you have been charged with?
Yes.
To this charge, Ms. Thomas, how do you plead guilty, not guilty, or no contest?
Okay.
Are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges? Ms. Thomas, I also have before me a document that is titled Misdemeanor Plea Admonishment. Do you recognize this document?
Yes.
On page 2 of this same document, there's a set of initials on a line next to a box that's checked no contendere, which means no contest. Did you place your initials on this document?
Yes.
On page 3 of this same document, there are a set of initials on a line, but there's a signature on a line next to a box that's checked defendant. Did you place your signature on this document? On page 3 of this same document, there's a signature. Well, on the next document, there's a signature on a line on the document that is titled Trial Court Certification of Defendant's Right of Appeal. You place your signature on this document. At the top of this document, there's one box that's checked. The box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The next box, well, the next document is titled Discovery Certification. Do you recognize this document? And is this your signature on the line that's titled Defendant? Ms. Thomas, before you sign and initial these documents, did your attorney go over these documents with you? Did you understand everything that your attorney went over? Is everything in these documents true and correct to the best of your knowledge?
Yes.
Ms. Thomas, are you a citizen of the United States?
State will offer, state one, Judge.
And we have no objections to stage one, Your Honor.
No objection, states exhibit number 1 will be admitted. And Mr. Paget, you have advised and counseled Ms. Thomas. Is there any evidence that she is currently mentally incompetent to stand trial?
None, Your Honor.
Ms. Thomas, your attorney, Mr. Paget, has advised and counseled you. Are you satisfied with his services?
Yes.
Ms. Thomas, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers was freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
It would be 18-month deferred adjudication, a $25 fine, 60 hours community service, and no contact with the victim, Alacia Simeon, Judge, as well as an anger management course.
That is our understanding, Your Honor.
Okay,
They're a high school student. Judge.
okay. Okay, Ms. Thomas, the state is offering that you serve 18 months deferred adjudicated probation. During the 18-month probationary period, let's see. What's the court cost?
277.
Okay, Ms. Thomas. The state is offering that you serve 18 months deferred adjudicated probation. During the 18-month probationary period, you'll be required to pay a fine of $25 plus court costs of $277. You'll be required to pay a probation fee of $60 a month, your analysis fee of $15 a month, reimbursement fee of $15. Your total monthly installments, that is the total amount that you will be required to pay each month, is $98 a month. Will you be able to pay the $98 each month? Okay. You will also be required to perform 60 hours of community service. And you cannot have any contact with the victim, in this case, Alasia Simeon. You will also be required to adhere to the other standard terms and conditions of this probation. Ms. Thomas, do you understand the state's offer? Do you think that the state's offer in your case is fair and just? Do you accept the state's offer? Oh, on a minute. That anger management on here too.
Yes, Your Honor.
Okay, you also be required to attend and complete anger management. Now, you say graduate from high school. Is that, oh, she's still in school?
That's correct, Your Honor.
What, grade? What grade are you in? Well, okay,
So she'll technically graduate during the course of this probation.
okay.
You're on course to graduate? Very good.
Okay, you also required to graduate from high
That
school.
was my understanding.
Now, Ms. Thomas, do you understand the state's offer? Do you think that the state's offer in your case is fair and just? And do you accept the state's offer? Okay, now, Ms. Thomas, I'll follow the plea bargaining agreement that you have entered into with the state. Now, Ms. Thomas, did you come here with anybody? Okay,
She has been, her mother was with her last time, and I've been communicating with her father through the whole incident. In fact, the case was reset last time. Mr. Williams allowed a reset because we wanted to discuss it, so.
okay. Now, Ms. Thomas, how old are you? 17, 18? 18. You know what? I used to be 18, 365 days. And, you know, I know that when I was 18, I had friends, and I'm sure you have friends. And I think today, these days, you call your friend your BFF or your ride or die. In my day, we used to call them our ace boon coon. And those are people that we figure will be with us through thick and thin, and when we down and out, they'll be there to pick us up. Okay? But on days like today when you need a friend, okay? That person that you probably call your BFF or your ride or die is not here. You know why? Because they got something else better to do than to be down here with you. Okay? Let me tell you this here. Everybody's not your friend. Everybody's not your partner. Your attorney was saying that your mom and your dad been here with you. So when they say they got you, they got you. Okay? And so you might think that this is the worst day of your life. You might think that you're in a storm, but just remember this. When you're walking through a storm, hold your head high and don't be afraid of the dark. At the end of the storm, there's a golden sky and a sweet silver song of a lark. Walk on through the wind, walk on through the rain, though your dreams be tossed and blown. Walk on with hope in your heart, and you'll never walk alone. Now, I mentioned to you that I was 18 years old for 365 days. That was many moons ago, a long time ago. But I've come a long way. You know, in life, in this journey that we call life, you're going to have storms in this life, okay? And sometimes you get in those storms, you start drowning in the sea of confusion. But just remember this, when you're drowning in the sea of confusion, hold on to hope, because hope floats, okay? I said that to say this. You still have hope, okay? Some people might look at this as a stumbling block, but you could look at it as a stepping stone. And people use stepping stones to reach high heights. You can reach any height that you want to reach in life, okay? Now, before this day is over, that person that you call mom and that person that you call dad, you need to give them a big hug, okay? Because you're fortunate. A lot of people come here, they don't have somebody they call mom or dad to be by their side and to give them the support that they need, okay? So you're blessed, okay? And if you successfully complete this probation, it would not result in a conviction on your record, and you may qualify for non-disclosure where your record will be sealed to the general public. You can talk to your attorney about the non-disclosure because he's quite competent in those matters, okay? Just hang on, don't hang up, okay? You can get your sign your paperwork and you'll be free to go.
Thank
I started to do like Judge Davis and say potatoes, okay? You can go ahead and get your reset.
Talk about, it made me think about Romans 12, verse 2.
Mhm.
Almost what you said. Blessed is the one who perseveres under trial.
That's right,
Having stood the test, that person will receive the crown of life.
that's right,
So you got a good, strong family.
that's
You
good,
got my chances.
okay. Okay,
Hebrews 12.
who do we have? Oh,
You know, honestly,
Brandon Venabush.
I understand that. So I understand that. Normally I would. Okay, you know, this.
Venabush, was that reset too?
Yes, Your Honor.
Okay,
We're working on King. It's the only one.
okay, 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 okay. All right,
and I'll let you know whether we can work it out.
Okay.
Sure.
this is,
It's,
this is cause number 25 CCCR 2552 case of Style State of Texas versus Alize Rios. Ms. Rios, is that your full name?
yeah.
How are you doing, Ms. Rios? I'm doing fine. Thanks for asking. Ms. Rios, you're represented in the case by your attorney, Laura Perazo. Ms. Perazo, how are you doing?
Doing well, Your Honor, thank you.
Ms. Perazo, what is your announcement in Ms. Rios' case?
Your Honor, I believe that Ms. Rios qualifies for pretrial diversion, so
Okay.
I would ask for a brief reset to allow me some time to do that.
Apply for pretrial diversion?
Yes.
Let's see, April, the next term is in April. We're gonna reset a second week in April. Okay.
April 13th.
Okay, this case will be reset to April 13th, 2026. Ms. Rios, you'll get your reset from our court coordinator. Once you get your reset, you're free to go, and you have a blessed day.
Thank you.
And Ms. Perazo, is this your only case? Is this your only case?
I have one more, Your Honor.
Oh, okay, Jason Young Senior. Mr. Young, your full name is Jason Young Senior.
Yes, sir.
How are you doing, Mr. Young? I'm doing fine. Thanks for asking. Mr. Young, you're represented by your attorney, Laura Perazo. Ms. Perazo, what is your announcement in Mr. Young's case?
Your Honor, I would like just a brief reset to allow the prosecutor some time to make an offer, and I need to discuss some things with them as well. April 8th.
Okay, this case will be reset to April 8th of 2026. Mr. Young, you'll get your reset from our court coordinator. Once you get your reset, you're free to go, and you have a blessed day. Thank you. And Ms. Perazo, you get your reset, you're free to go as well. You have a blessed day. You're welcome. Mr. Macy, what are you,
We good, I think it's ready.
It's not ready.
it's not ready yet? Okay. Okay. James, make that one. Mason Sonia. Sonia, depends on. He's here. Mr.
We need to place that over on the trial docket at this time.
Okay, that's Miss Nixon's case. Now, you pronounce it Sonia or Sonia?
Sonia.
Sonia, okay. Yeah, I'm from the other side of the river too.
Yes.
I'll give you a call.
Okay, give us a reset date. Huh?
It'll be April 6th.
April 6th. Okay, Mr. Sonia, this case will be reset to April 6th of 2026. You're gonna get your reset. Once you get your reset, you're free to go. And you have a blessed day, Mr. Macon. Got to ask you how you was doing?
Yes, and thank you very much for agreeing to come
Oh, that's
talk to
no,
the Democratic women.
well, no problems.
I think they'll love your story.
Okay. Okay.
Good morning. It's slow this morning.
We have to do something, that's just one reason. Yeah. We love us.
I'm gonna be here. Very nice. Very nice.
I mean, yeah.
Yeah.
Doing great.
See if I have it for saves. Okay, we have Carlo Landry. Carlo Landry, who's that? Okay. Let's see. Mhm. Landry. Signature. Okay. Landry. Motion, okay. Mr. Landry, your full name is Carlo Landry? Okay, Mr. Landry, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Landry, you may put your hand down. How are you doing, Mr. Landry?
Great. All right.
Oh, I'm fine. Thanks for asking. Now, Mr. Landry, I have two cases before me. First case is cause number 24 CCCR 2644. And in this case, I have a motion to revoke your unadjudicated probation. In this motion, it alleges that, let's see, let's say, okay. Let me make sure. Yeah, okay. Okay, Mr. Landry. In this motion, actually, this motion was filed by the Jefferson County District Attorney's Office. In this motion, it alleges that you, Carlo, that's Richard Landry, on or about July 7th of 2025, well, in County Court at Law number 2, that you were found that the evidence was sufficient beyond a reasonable doubt to support a finding of guilt for the offense of failed to identify a fugitive with intent to give false information. The court placed you on probation, on unadjudicated probation, after deferring adjudicating your guilt, and you were placed on probation for 2 years. in this motion, let's see. There are 3 allegations. First allegation alleges that you, Carlo Richard Landry, committed the offense of assault causing bodily injury to a family member on or about the 15th day of September 2025, Jefferson County, Texas, in violation of condition 1 of your probation order. Allegation number 2 alleges that you, Carlo Richard Landry, failed to pay court assessed fees as ordered by the court. And as of November 6th of 2025, he was $540 in arrears in violation of condition 9 of your probation order. Allegation number 3 alleges that you, Carlo Richard Landry, failed to perform community service hours as required by the order, your probation order, in violation of condition 17 of your probation order. Now, Mr. Landry, if the court finds that any one of these conditions are true, your punishment can be assessed up to 365 days in the Jefferson County Jail. Do you understand?
Yes, sir.
Now, the next case, clause number 24 CCCR 2833. I have before me, in this case, a motion to revoke your unadjudicated probation. And in this motion that was filed by the Jefferson County District Attorney's Office, it alleges that you, Carlo Richard Landry, on the 7th day of July 2025, in County Court at Law number 2 of Jefferson County, Texas, that the court found the evidence sufficient beyond a reasonable doubt supporting a finding guilt for the offense of driving while intoxicated with a Class B misdemeanor. However, the court deferred adjudicating you guilty and placed you on deferred probation for a period of 2 years. In this motion, there are 3 allegations, and the allegations actually are the same allegations, with the exception that allegation number 2 states that you failed to pay court assessed fees as of November 6th of 2025. At that time, you were $200 in arrears in this case. It also states that you failed to perform community service, as well as allegation number 1 alleges that you committed the offense of assault causing bodily injury to a family member on or about September 15, 2025 in Jefferson County, Texas, in violation of condition 1. Now, if the court find that any one of these allegations are true, your punishment can be in excess up to 180 days in the Jefferson County Jail. Do you understand that?
Yes, sir.
Now, as a defendant in a criminal case, you have a right to have an attorney. I have a document before me that's titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant?
Yes, sir.
Or are these your initials
Yes, sir.
on the line that state you like to apply for court-appointed attorney? I also have a document that is titled Jefferson County Affidavit of Injuries. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that is titled Defender Signature. Is this your signature?
Yes, sir.
Now, before you sign and initial these documents that I'm showing you, did you read the documents?
Yes.
Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Yes, here. Okay, Mr. Landry,
Yes, sir. Yes, sir.
the court finds that you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in this case is Attorney William Wilkerson. Attorney Wilkerson will be given information to represent, to contact you, and you will give him information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go. and you have a blessed day. Okay? Yes.
So on the three, incidents, on the first one, our son, they was dropped. How do I do this?
Well, I can't give you no advice. You can talk to your attorney
Okay,
about what you need to do.
yes.
Okay? All right, just stand in front of the court coordinator. All right.
Yeah. His name's, I'm sorry.
Okay. Hey, this is cause number 25 CCCR 1584, case is style of state of Texas versus Twila King. Ms. King, is that your full name?
Yes.
How are you doing, Ms. King?
I'm good.
That's good, Ms. King. You're represented by your attorney, Ms. Paget. Mr. Paget, what is your announcement in Ms. King's case?
Your Honor, the state has additional research to do on this case. We asked for a reset.
Okay,
That's
Mr.
fine.
Standard reset.
Yes, Your Honor, and quite frankly, there's some information I would like to get to Mr. Williams as well. And in his defense, it's the first time I've spoken to him about it. I think he took the case over from another prosecutor. And I appreciate his diligence, but
April 8th.
I appreciate him taking the time. to look
Okay,
at
this case will be reset to April 8th, 2020. Is that the date or?
it. Yeah, that's that. There you go. Thank you so much. It's the day to have a conflict. I want to be able to put the time into the case.
April 15th?
Yes, Your Honor.
I look forward to your share, Mr. Patrick.
Okay, this case will be reset to April 15th
You're gonna shout all day.
at 9 AM. You're gonna get your reset. Once you get your reset, you're free to go and you have a blessed day. And Mr. Let's see, you have Macy's.
Any questions?
Who did you have first?
I sent you a dismiss.
He said,
Alizé?
Yes, sir. It had been, Alice had been reset, Judge.
Yeah,
I informed Ms.
Peraza. Yeah.
Oh, it had been?
No, it was after it was reset and it dismissed it.
Your Honor, may I be excused?
Yes, you may.
It's my last case. I didn't want.
Yeah. I think they're gonna cut him off here if they get one.
Yeah, you have to still put it in. Mark Andrew Crocker. Who's his attorney? Who's representing Crocker? Who's his attorney?
Oh, I'm sorry.
Oh,
Fine, Judge.
Crocker. Let me see. Okay, this is cause number 25 CCCR 2568. Case is styled in the state of Texas versus Mark Crocker. Mark Andrew Crocker. Mr. Crocker, is that your full name? Mr. Crocker, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Crocker, you may put your hand down. How are you doing, Mr. Crocker?
Pretty good, Your Honor.
That's good. And Mr. Crocker, that's what you say?
How about yourself?
Oh, I'm doing fine. Thanks for asking. Now, Mr. Crocker, you're represented in your case by your attorney, Attorney John Macy. Mr. Macy, do you waive a record in Mr. Crocker's case?
Yes, Your Honor.
Mr. Crocker, I have before me on my computer a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Mark Andrew Crocker, on or about August 15th of 2025, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of resisting arrest detention. Mr. Crocker, do you understand what you have been charged with?
Yes, Your Honor.
To this charge, Mr. Crocker, how do you plead guilty, not guilty, or no contest?
Okay.
Are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges?
Yes.
Mr. Crocker, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, Your Honor.
On page 2 of this same document, there are a set of initials MAC on a line next to a box that's checked no contendere, which means no contest. Did you place your initials MAC on this line? On page 3 of this same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, Your Honor.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, Your Honor.
Now, your name, you wrote your name below the line that is titled Defendant. Did you place your signature on this document that's titled Trial Court Certification to Defendant's Right of Appeal?
Yes, Your Honor.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? And I also have before me a document on paper that is titled Discovery Certification. Do you recognize this document?
Sir, I can't see very good.
Could you show that to him? And Ms. Nixon, you need to sign it.
Yes, sir. Got
She needs to sign
cataract. I don't see too good.
it. Okay. Now, Mr. Crocker, before you sign and initial all of the documents that I showed you, did your attorney go over these documents with you?
Yes, Your Honor.
Did you understand everything that your attorney went over?
Your Honor.
Is everything in these documents true and correct to the best of your knowledge?
Yes, Your Honor.
Mr. Crocker, are you a citizen of the United States?
Yes, sir.
State, do you like to offer State's Exhibit number 1?
So offered, Your Honor.
Any objections?
No objection, Your Honor.
No objections. State's Exhibit number 1 will be admitted. And Mr. Macy, you have advised and counseled Mr. Crocker. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Crocker, your attorney, Mr. Macy, has advised and counseled you. Are you satisfied with his representation? Has he provided full, effective, and competent legal representation?
Yes, Your Honor.
Mr. Crocker, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, we do, Your Honor.
And what is the agreement?
Yeah, the essential term falls 30 days in jail, in county jail, with credit for 2 times served, time actually served, and all court costs to be tax retired.
What's the court cost?
287.
Do we have a copy of his affidavit? You were appointed in this case, right?
Yes, Your Honor.
Mr. Crocker, the state is offering that you serve 30 days in Jefferson County Jail. You'll be given credit for the 2 days that you have already served. The court cost in this case is $287. Are you able to pay the $287 court cost?
Say that.
What did he say?
And I did that after my time. That's.
Well, I just need to know if can you pay it or not? You can't pay it, okay. I know, understand. Just hold on a minute. Okay, now, Mr. Crocker. I have before me a document that is titled Jefferson County Affidavit of Indigence. I'm gonna hand this document to your attorney, and your attorney will hand that document to you. Do you recognize that document?
Yeah.
Now, is everything in that document still true and correct today?
Yes, sir.
Okay, Mr. Crocker, the court is going to find that you are indigent. Based on the finding of indigency that the court has made, the $287 in this case will be waived pursuant to Article 42.15 of the Texas Code of Criminal Procedure. That means you won't have to pay it.
Thank you.
Okay, now, Mr. Crocker, do you understand the state's offer?
Yes, Your Honor.
Do you think that the state's offer in your case is fair and just?
Yes, Your Honor.
And do you accept the state's offer?
Yes, Your Honor.
Now, what is this?
Your Honor, we would ask that Mr. Crocker be allowed to turn himself in on consecutive Fridays until it's 30 days
So you're gonna serve it on weekends?
on the weekends. Yes, Judge. And that's
Yeah, but you have
30
to,
days. That's probably more than he'd have to actually do. If
well,
they
it should
give him
be 28 days. I mean, 28. So he get 3 for 1. I mean, but
Yeah, if he gets 2 for 1, it's probably half of that, but.
Yeah, I'm just saying.
28.
but if you go in on Friday, get out on Sunday, that's considered 3 days.
Right.
Because
So-
it's 3 different days, even though it's 48 hours. But anyway,
Right.
um,
And so I put on there as of the exhibit, actually there's 29 days on there, but the sentence is 30. So whatever the jail would calculate would be, I guess, however long he'd have to do.
yeah, and then they may
Uh,
give him credit too. They may
yeah.
give him good time credit. Now, do you have that in the, but you're gonna have to put that he goes in at 6 p.m. and get out at, he has to turn himself in on or before 6 p.m. on are at 6 p.m.
Every,
on or before 6 p.m. on the Fridays that are listed in the adjustment. Okay, okay,
Thank you, sir. Thank you.
okay, you're welcome. Now, Mr. Crocker, do you understand the state's offer?
Yes, Your Honor.
Now, his jail time is gonna start March 6th, 2026.
is it Friday, Judge?
That must-
I thought it was 7.
Today is the 4th,
Oh, okay. Did I
and
put the wrong
today is
date?
Wednesday. Oh, but you you have it on the
Oh,
6th.
okay, March, yeah.
March 6th,
6, okay.
at 6 p.m. And you're gonna start in consecutive weekends until your time is served.
Appreciate it.
All right? Now, Mr. Crocker, do you understand the state's offer?
Yes, Your
Do
Honor.
you think that the state's offer in your case is fair and just?
Yes, Your Honor.
And do you accept the state's offer?
Yes, Your Honor.
Mr. Crocker, I'll follow the plea bargaining agreement that you have entered into with the state. Mr. Crocker, you'll stand next to. Okay, you're gonna shred that. Yeah. Just have a seat in that chair on the wall. Wait for your name to be called. Once your name is called, you'll be free to go. And you have a blessed day. And I see that you have a sticker. You're a veteran.
Yes, sir.
Thank you for your service. What'd you say?
And the President War.
Oh, wow.
I couldn't wait to join.
All right. Thank you for your service.
Two paratroopers that time, 15.
All right.
So, I'm looking good.
Yeah.
Well, may not like to agree with it.
Well, I couldn't be here if it had not been for people like you being there.
Appreciate it.
Okay? All right.
Attach that to the.
You gonna test this?
Yeah, we have, because it's not on the NPN, but I'm gonna print it out and scan it.
Oh, okay. No,
As long as the date's on there.
it has a date, but it don't have a time.
She could put, well, he could put the time.
Yeah,
You could put 6 p.m. and then
yeah.
on these things, 6 p.m. and
Okay.
Well, it's 6 p.m. Friday through
6 p.m.
to 6 p.m.
The
Yeah,
end.
only thing you have to put it, yeah, that's beginning date and the ending date. Okay, hold on a minute.
So.
Okay. This is cause number 25 CCCR 2234, case of South the state of Texas versus Luis Humberto Correa. Mr. Correa, is that your full name?
Yes.
How are you doing?
Wonderful.
Okay,
You.
I'm doing fine. Thanks for asking. Mr. Correa, you're represented by your attorney, Ms. Provo. And Ms. Provo, how are you doing?
I'm doing fine.
That's good. Ms. Provo, what's your announcement in Mr. Correa's case?
Okay, we just got an offer in this case, so we need, like it to remain on the announcement document for another.
Okay, we're gonna reset for an announcement. Get us a reset date.
April 8th.
This case is reset to April 8th, 2026. Ms. Correa, you get your reset from our court coordinator. Once you get your reset, you're free to go and you have a blessed day.
Thank you.
Okay, you're welcome. Brett Austin Stanley. What are we doing on that?
We should submit his name for pre-trial, DWI.
Okay. This is cause number 25 CCCR 2228, Jason Styles, the state of Texas versus Brett Austin Stanley. Mr. Stanley, is that your full name?
Yes.
How are you doing, Mr. Stanley? I'm doing fine. Thanks for asking. Mr. Stanley, you're represented by your attorney Provo. Ms. Provo, what is your announcement in Mr. Stanley's case?
Your Honor, I will submit his name to the DWI pre-trial diversion program.
Okay, give us a reset, and that's in April.
That'll be April 13th.
Okay, this case will be reset to April 13th, 2026. Give your attorney opportunity to apply for pretrial diversion on your behalf. Now, Mr. Stanley, you get your reset from our court coordinator. Once you get your reset, you're free to go. You have a blessed day and you look nice. Okay, you're welcome.
May we be excused, Your Honor?
Yes, Ms. Provo, you may get excused.
Okay, thank you.
You're welcome.
I'm writing this one.
Morgan Elizabeth Weatherly.
Yes, Your Honor.
Ms. Weatherly, your full name is Morgan Elizabeth Weatherly.
Yes, sir.
How are you doing?
Hope you do well.
That's good. Ms. Weatherly, you're represented by your attorney David Grove. And Mr. Grove, how are you doing?
Good, Judge. Thank you.
That's good. Now, Mr. Grove, what is your announcement in Ms. Weatherly's case?
Judge, this is our first setting. I'd like for 30 days or something like that so I could investigate the case more because I'm not prepared to go forward. I have discovery from the DA's office, but I need to check on some things.
Okay, give us a reset date.
April.
Okay, this case is reset to April 8th, 2026. You're gonna get your reset from our court coordinator. Once you get your reset from the coordinator, Ms. Weatherly,
Yes.
you'll be free to go and you have a blessed day. And Mr. Grove, once you get your reset, you're free to go as well.
Thank you.
And you have a blessed day. Did his guy ship?
We just.
Did,
Yes, sir. How you doing?
Okay, now, Mr. Hawkins, your full name is Robert Lee Hawkins II, is that correct? How are you doing, Mr. Hawkins? I'm blessed as well.
Yes, indeed.
Now, Mr. Hawkins, your attorney of record in this case is Mr. Brian Matuska. Mr. Matuska is not here because Mr. Matuska is no longer a private practicing defense attorney. He has taken a job with the Federal Public Defender's Office. So therefore, we have to appoint you another lawyer. Okay? Actually, the next person on the list is Attorney Don Boudreaux. That's Mr. Boudreaux sitting right there at the table. Mr. Boudreaux, we're going to appoint you to represent Mr. Robert Lee Hawkins. He was previously represented by Ryan Matuska, but Matuska is now working for the Federal Public Defender's Office. So we're gonna appoint Mr. Hawkins to you, okay? Now, we're gonna give you some information on how to, I guess, stay in contact with Mr. Boudreaux. And we will also, Mr. Boudreaux, we'll give you his contact information, okay? If y'all wanna talk today, y'all can. But you can have a seat in that first chair on the wall and wait for your name to be called. Okay, we'll appoint you to represent him.
Oh, how do you go in?
No.
You're represented by Attorney Ryan Matuska. And as I mentioned to Mr. Hawkins, Mr. Matuska is no longer in private practice. He's now working for the Federal Public Defender's Office. And so I have to appoint you another lawyer. Okay, so the next lawyer that's on the list is Attorney Tom Burbank.
The gentleman that was right there, but I got a question.
That's the gentleman Tom Burbank wasn't in here.
Oh. Oh,
He hadn't been here today.
well, that's somebody different, okay.
Yeah. So, Tom Burbank is going to, be given information on how to contact you, and you will be given information on how to contact him. Our court coordinator will give you that information. Once you get that information, you'll be free to go and you have a blessed day. Please have a seat in that chair.
I got a question, because, when I talked to, Mr. Ryan or whatever, the communication issue with my son,
Oh, hold on, let me do this here. Mr. LeBlue.
Yeah.
You have a right to remain silent. Anything that you say can and will be used against you in a court of law. You have a right to have an attorney before and during any questioning. Now, I'm not gonna ask you any questions that's, I'm not gonna interrogate you.
Yeah.
But, if you have, anything to say about your case, don't say it to me.
oh,
You need to say it to your attorney. Okay?
well,
Because whatever you say now is not gonna, resolve your case today.
oh, I'm not trying to resolve.
Or whatever, but I don't need to know any information about your case because there's a time and a place for that. The time normally is during trial. They'll have the evidence.
Anything resolved in that manner, it's just a matter of my son being able to pick up stuff from his grandma.
Well, you can talk to your attorney about that.
Okay.
Okay? All right, just, have a seat and wait for your name to be called. Once your name is called, you're free to go and you have a blessed day. Stay in contact with your attorney and your bondsman. Which one he filed the motion to withdraw?
Yeah.
Okay. I'm gonna have to sign, that's gonna be ran in. And rescind the other one. Okay, this is cause number M 332-524, case of style of the state of Texas versus Hector Ernesto Maldonado. Mr. Maldonado, is that your full name?
Yes.
Mr. Maldonado, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Maldonado, you may put your hand down. How are you doing, Mr. Maldonado?
Bless her name.
I'm blessed as well. Thanks for asking. Now, Mr. Maldonado, I have before me a document that is titled Motion to Revoke Probation. This motion was filed by the Jefferson County District Attorney's Office. In this motion, it alleges that you, Hector Ernesto Maldonado, was tried on July 19, 2022 for the Class B misdemeanor offense of reckless driving. The court found that the evidence was sufficient to find you guilty, and your punishment was assessed at 30 days confinement in Jefferson County Jail and a fine of $200. In this motion, there are three allegations. Allegation number one alleges that you, Hector Ernesto Maldonado, failed to pay court assessed fees as ordered by the court, and as of December 21st, 2022, you were $907 in arrears in violation of condition 8 of your probation order. Allegation number two alleges that you, Hector Ernesto Maldonado, failed to perform community service hours required as ordered by the court in violation of condition 14 of your probation order. Allegation number three alleges that you, Hector Ernesto Maldonado, has failed to attend and successfully complete a driving safety course as ordered by the court in violation of condition 16 of your probation order. And allegation number four alleges that you, Hector Ernesto Maldonado, has failed to report to Jefferson County Probation Department by web or mail for the months of October, November 2022 in violation of the special amendment dated July 22nd of 2022 of the defendant's, of your probation order. Mr. Maldonado, if the court finds that any one of these conditions are true, your probation can be revoked, and if your probation is revoked, punishment can be assessed up to 30 days, up to 30 days in the Jefferson County Jail and a fine of up to $200. Do you understand that?
Yes, sir.
Now, Mr. Maldonado, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without an Attorney, because you have a right to have an attorney. In this document, there are a set of initials on a line that state you'd like to apply for a court-appointed attorney. Is that correct?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
On the next document that's titled Jefferson County Affidavit of Indigence, do you recognize this document? And you didn't date it. Hold on a minute. 3, 4, 6. It's the 4th. Sure. 6. Let's see, this 22. Okay, now, Mr. Maldonado, I see here, I'm looking at your affidavit. And do you own a vehicle?
No, I'm paying one.
Okay, that's fine. Okay, so I notice here on the transportation costs, you just have $100. Now, on the transportation costs, what you need to do is list the gas, if you're paying a car note, and if you're paying car insurance. Okay, you have to add those up. So I think the $100 is just gas.
Yeah, a little more.
Right. Well, when I looked at it, I was saying,
Yeah.
yeah.
I wish.
Yeah, your car note must be 0 or no insurance. Yeah, you can hand this back to him. Is there a pen? Yes.
Yes.
Yeah, reach out to the attorney. Ms. Woodrow, we gonna email you this.
Can you hand me one?
Okay, you good? Well, yeah. Okay. Here you go, Ms. Woodrow. But we.
Okay. His information is on there, right? Oh, we're gonna have to add this up. You added 800 to that, so,
No, to the total.
right. Right. So that was, 207. Yeah. Okay. That's that's 35.50. Okay, Mr. Maldonado, the court is gonna find that you're indigent. And based on the finding of indigency, you will qualify for a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Christy Carter. Attorney Carter will be given information to contact you. And you will be given information to contact her. This is Mr. Maldonado. He's on the MTRP docket. Hector Maldonado.
Here.
He has a now I'm gonna be around. Okay, Mr. Maldonado, please have a seat in that chair on the wall, and wait for your name to be called to give you a reset.
Yes, no, thank you.
All right, you're welcome. Ms. Rubin. We're gonna reset Ms. Rubin's case. Ms. Rubin, would you please come forward? Now, Ms. Rubin, how are you doing? All right, now your attorney was here earlier. He's in another county in court, and so your case will be reset. Right. You're gonna get your reset from our court coordinator. Once you get your reset, you'll be free to go. Yes.
Sir, may I ask if the bond conditions have been set yet? The reason I
On
ask is
what?
there's on the MTRP.
Normally, on the MTRP, we use it on set bond conditions because of conditions of probation suffice, but she's still on probation.
Yes, sir.
Right.
Okay, I had a request from an officer.
Hold on. Well, let me see. Yeah, I don't,
What about from
hold on a minute.
DWI?
Hold on a minute. Let me see, MTRP document. Hold on, you know what? Let's see, MTRP. That case is not on here.
The DWI?
The only DWI is the MTRP. Is that, hold on a minute, let me look at the allegation, has it been filed?
Yes.
The second case.
Oh, I just have 0990. Is that
Okay, that's this, hold on a minute.
What's the person's name?
Ruben?
Nadia Rubin.
Let me look at it. The allegations are in the motion to revoke probation. Okay, let's see what. Let's see if there's some bond conditions in the file. On the other case. Well, the other case is not, I hadn't set bond conditions because it wasn't a case in this court. Yeah, there is a a law violation. Do that committed to DWI on November, that's gonna be a DWI second. Now, she was booked in on that case. Who did the magistrate set a bond? The magistrate who booked her out on November 12th of 2020. Well, we won't have access to it if that case hadn't been filed. Y'all might have access to it. Cause y'all might have a DA number, not a,
He's looking it up. This thing.
okay.
We show nothing in our system being brought to our office as a gift. Oh, Miss Nadia Rubin?
Yeah, but she was arrested on it.
Yes.
Yeah, so I don't,
Nothing has been presented.
yeah,
When we do the reset, can we do a short reset so the probation office can file a motion to add a scram? She since.
Oh, okay.
Since the time of this arrest for DWI, she showed up testing positive for alcohol in a vehicle, not containing the interlocked device.
Okay, well,
That's
you could,
just-
you
so
could-
we could reset to,
we can do it. It's gonna be reset. Y'all can file the necessary motions.
yes, sir.
Okay. Okay. So I guess they may amend the M2 too, I guess. I don't know. You're gonna get your reset? Once you get your reset, you're gonna stay, you're gonna talk to her before she leave?
Yes, sir, I can.
Okay, you're gonna talk to him before you leave, okay? You get your reset and you'll be free to go. You have a blessed day. Now, Ms. Keel, this is cause number 25 CCCR 9734. The case of South State of Texas versus Brianna Keel. Now, Ms. Keel, how are you doing?
Well, so.
I'm doing fine. Thanks for asking. Now, Ms. Keel, you appeared in court on January 27th of 2026. On that day, you stated that you wanted your case reset to hire your own attorney. And have you hired your attorney?
As of Friday, I will have hired one.
So you're gonna have an attorney this Friday? Okay. Give us a reset date. Okay, this case will be reset to April 8th, 2026. Now, Ms. Keel, if you hire an attorney, as you say, Friday, your attorney is probably going to send this court a letter of representation informing this court that they have been hired by you. And then once we get the letter of representation, we'll probably give your attorney another court date, different from the date, but your attorney would have to inform you that it has changed. But if he hadn't informed you that the date hasn't changed, you need to be here on April the 8th.
Okay.
Okay? You can get your reset. Once you get your reset, you're free to go and you have a blessed day. Did you get the Mr. Burbank's reset? I'm gonna reset. He's in court in Hardin County.
That's the beginning to remind y'all on this week, so.
Okay, the court is back in session in cause number 24CCCR 0990. Now, Ms. Rubin, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Rubin, you may put your hand down. Now, Ms. Nixon, we have a
Motion.
motion amending the terms of your community supervision. Hold on a minute. Okay, now, Miss Ruben, I'm going to give you some bond conditions. Okay? And it states that standard bond conditions in County Code at Law number 2, following the return of criminal information in County Code at Law number 2, all bail bonds executed for release from any defendant named herein or ordered subject to the additional condition number 1. Defendant shall commit no offense against the laws of this state or any other state. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition? Now, condition number 3 does not apply. Condition number 4 does apply. And it states the defendant whose information charges, I'm gonna say any offense listed under section 49.04 through 49.06 of Texas Penal Code shall not operate any motor vehicle unless the vehicle is equipped with an interlock device mechanism that makes impractical the operation of the vehicle if ethyl alcohol is detected in the breath of the operator, and said device shall be installed at the defendant's expense with written verification of such installation being submitted to the court. On or before 3 days after today. So you cannot operate a motor vehicle that does not have an interlock device. You understand that? Yes, sir. Now, if you do not have a vehicle, you don't have to have an interlock. But if you're gonna drive a vehicle, if you don't have a vehicle, you don't have to put a vehicle on the interlock on a vehicle because you don't have one. But if you drive somebody else's vehicle, you have to have an interlock. Okay, so you can't drive nobody else's vehicle without an interlock being on it. Okay. Okay? Now, you must obtain, maintain, pay for, and have no violations with the ignition interlock device or mobile device or scram device. Any violation will be reported to the, you cannot have any violation. If you do, your bond can be revoked. Okay. And you must complete an evaluation and or treatment with addiction treatment and with ATAR, addiction treatment assessment, addiction treatment and recovery program with Spindletop, right? Okay, do you understand? Yes, sir. Okay, now if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand? Yes, sir. Now, let me do this here, and this will conclude this case. All right, and this will conclude calling of the court's motion to revoke probation docket and announcement docket on the day's date, March 4th, 2026, County Court at Law number 2. Judge Terrence Holmes presiding, court will be in recess until 1 p.m. to resume our trial, our jury trial.